All right, good afternoon. My name is Linda Ruffalo. I'm the Vice President of the Kenosha Women's Network, and it's my pleasure to introduce today's speaker. Her name is Amanda McCormack. Amanda is an accomplished estate planning attorney with nearly 20 years of experience. She helps families navigate through important decisions. She's originally from Neenah, Wisconsin. She earned her Juris Doctorate degree from Marquette University in Wisconsin, of course. And beyond her impressive legal background, she is a wife, a mother, a volunteer, a fitness enthusiast, and a proud dog rescuer. Her expertise and compassion make her a trusted and respected person in our community. So please welcome Amanda.
Well, thank you all for having me out today. I recently opened a little office in downtown Kenosha, and I've been welcomed so warmly to this community. It's just been an incredible experience so far. I am an estate planning attorney. I actually started as a paralegal and went to law school just to be an estate planner. I love this area of law. It's my passion. I love helping people plan for death and incapacity. But really what I love doing is having the opportunity to meet with families and then walk them through and walk their families through some of the toughest times that are going to happen. Raise your hand here if you know the exact date that you're going to die. Raise your hand if you love to talk about death and incapacity. Only maybe one.
We have one over here.
And one over here. Yes.
She's a hospice director. So
yes, that makes sense. So when we think about these topics, we all know that inevitably death or incapacity is going to happen. But we really don't like to think about it, and we really don't like to talk about it. It seems pessimistic, but planning is not pessimistic. Planning is being realistic with the fact that we're human, and it's gonna happen to all of us. And so I wanna talk about a few misconceptions that we have about estate planning and what it is. The first one is that a lot of people hear estate planning and they think, I'm not rich, I don't need to do estate planning. Estate planning is not so much about what you have, it's who you are, who the people are in your life, and the stuff that you have. So it's setting instructions in place so that your family knows what you would like done with your stuff, sure, but also what you would want done for you if you can't speak for yourself. So those types of decisions have nothing to do with what's in your bank account. If you get into an accident or you have dementia, we're all aware that science is improving to the point where we're living a whole lot longer, but we're not always living better yet. If we get in an accident or we have a condition where we can't make decisions for ourselves anymore, somebody needs to step in and make decisions for us. If we don't leave guidelines behind, then how are they going to know what we would want done for ourselves? Again, decisions that aren't tied to assets at all. It's true that the more assets you have, the more planning we might need to do. So that's one misconception. Another misconception is, well, my family, they'll figure it out. They'll know what I want to do. Does anybody here ever disagree with a family member? And do they ever disagree with each other? The problem is that not only can we have disagreements about what we would want done, and what decisions should be made for us, we have to give them the authority, the legal authority, to even make those decisions. And if we don't give them the authority in the proper way, then the court has to step in. And if the court steps in, then they're going to be the ones that are naming or picking who is going to be making those decisions for you. and it might not be who you want to be making those decisions. So your family may have the best of intentions, but in order to ensure that we have the right instructions and we've got the right people making the decisions for you, we do planning so that we have your thoughts laid out properly and we've got the right people making those decisions. The next misconception that I hear a lot is, I have a will, so I'm avoiding probate, right? Anytime you hear the name of a document, a will, a power of attorney, a healthcare directive, those are just tools in an estate planner's toolbox. And that tool has a specific job. Just like a hammer hits a nail, you don't use a hammer to saw a log. You have to know what that tool is used for. A will is actually a document that is specifically written to the probate court. It's for the probate process. And depending on how your assets are owned when you pass away, determines if that will is going to be processed through the probate court. So if we want to avoid probate, the will is not the document that we are going to use as our primary tool to do that. So in order to do planning, we've got to take a look at your assets, we've got to figure out how they're owned, and then we've got to line up the right tools to make sure that for all of your assets, we're avoiding the probate system while still getting them where you want them to go. Fourth, we hear, I'm too young to worry about that. The best case of even when you're young, you need an estate plan is the college student. My daughter is 23 years old. She just recently graduated from college. If she were to have gotten into an accident while she was in college, if she did not have at least a healthcare power of attorney and a financial power of attorney, I have no legal authority to get information from the hospital, to get updates about how she's doing, or to step in at her bank and make sure that her bills are getting paid, her rent is getting paid. So even in the negative asset situation where we've got a college kid who has more debt than they have money in the bank, parents can be caught off guard when they don't have any legal right to step in and help their kids in those circumstances. So there is no too young to need estate planning. It's just we may need simpler estate planning at that time. Let me look at my list and make sure that I've got, and the last one is, well, I signed my plan 20 years ago, so I should be fine. Having something is always better than nothing, I will say that. But you change over time, your circumstances change over time, and the laws change over time. So at least every 3 to 5 years, even if you have a really great estate plan, you should be revisiting it so that all of the pieces continue to work the way that you intend them to work. And whether it's just reading through it and connecting with whoever assisted you initially, or having somebody new take a look at it, it's just a good idea to revisit it to make sure that there's not a surprise in there. And it's not just the documents. Again, you're going to want to look at the documents you might have in place, plus the assets that you have, how they're owned, and how any beneficiaries might be listed. So that is my little presentation for you today. If you have any other questions, I'd like to open up the floor for any questions. Yeah.
So what is the difference then between a will and estate planning?
So estate planning is the overarching category of getting the documents together for planning for incapacity and planning for death. A will is one of the tools in the toolbox that we use for directing assets at death.
How specific do they need to be in the will? What if it just says divide by 4?
So if it says, you mean just between 4 beneficiaries?
Yes.
If the will says to divide by 4, and those 4 people are alive and just fine, then it can work out just fine. And all of the assets are passing under the will. But let's say that you, when you did your will, you were married and you had 4 kids. And then you, your husband passed away and you got remarried and you owned everything in joint tenancy, and then you passed away. And then your new husband passed away. Okay? You following here? Yeah. I wish I had a big chalkboard. So when you have a will,
Yes.
your assets that pass under a will are only assets in your individual name without a beneficiary form. In a state like Wisconsin, when you're married, most assets are owned jointly. When you own assets jointly, by operation of law, doesn't matter what your will says, they pass to the surviving joint owner, not by your will. So what happens if we don't take a look and make sure that we're coordinating all the pieces is you and your husband have mirroring wills that say everything goes to each other first, and then if something happens to both of us, it gets divided by and goes to our 4 kids. One of you passes away, the survivor is like, I've still got life to live, I'm gonna get remarried, they own everything in joint tenancy, then you pass away before your new partner, all the assets go to that person, your kids are cut out. Nothing passes under that will.
That's terrible. What if you have a trust versus a will? Yeah, what is that?
Yep. So trusts are what we consider the Cadillac of the estate planning world. They are another tool in the toolbox. They're used a lot because they avoid probate and they deal with both incapacity and death planning. The reason why trusts are often used in situations like that is because if we have a trust, we can plan for that scenario. We can title assets in the name of the trust. We can say, okay, if one of us passes away first, honey, I love you, but some of these assets are going to be protected so that with real certainty we can get some down to our kids, even if there's a remarriage. So trusts allow us flexibility to do better contingency planning along the way.
See?
As a financial advisor, we were talking about a trust and whether or not we needed to do one. And her comment was, look, I always recommend them if you want to control your estate after you're gone. For instance, if there's a child who's disabled, something like that. But short of that, she said, other than that, you don't really need to worry about it.
It's useful in a whole lot of scenarios. I would say more often than not, it is the tool of choice. There is a subset of scenarios where it would be too much planning, but it is a pretty small subset. A lot of times what I found with financial advisors in general, they're fantastic at what they do, but as professionals, we all have a lens that we're looking through. And they're looking through the lens of making sure that your money is working for you and then getting it to the next layer and making sure that the money is working for the next people that they're getting it to. So they're looking for what is the fastest way that we can move it from you to the next people. Trusts slow that process down intentionally because we are doing some intentional planning between when you pass away and when we get it to your next layer. And so that feels less efficient sometimes without a little bit of understanding of the why underneath.
So I've been told that even if you have a will, it still goes to probate. But when you have a trust, it doesn't go to probate.
Correct.
Okay. Okay.
So it's not because you have a will it goes to probate, it's that a will is written for probate.
Okay.
And what triggers a probate is assets in your individual name, and in Wisconsin, the threshold is only $50,000.
Okay.
So once we exceed that with real estate in your individual name or
It's
cars,
going to probate. But the trust stops that from happening.
the trust is the tool that we use, but it's tied to title. So if you get a trust done with an estate planning attorney, they'll put your house in the trust, and then they'll give you instructions on lining the rest of your assets up.
Okay.
All right, we have time for one more question, Denise.
Yeah, upon the forms that transfer upon my death that you get notarized, do you avoid the probate with those, or
Yes.
is
So
it just for a house or certain items?
So beneficiary forms, including a transfer on death deed for a house, avoid probate. What they don't do is allow us to do any contingency planning. So you can name who gets it. We don't get to say what happens if that person passes away first or is disabled. The other issue that can come up with just naming who is sometimes people have 3 kids, they put all 3 kids on a transfer on death deed, and I don't know about you, I have 2 sisters, sometimes we don't get along on everything. And so then we end up in court fighting over what to do with the house after. So those are just some of the things we've got to talk through. None of the tools are good or bad. We just have to be intentional about using them.
If you have a general POA, does it also cover medical POA?
No.
So you have to have 2 separate documents.
Correct. There's a financial power of attorney and a health care.
There is this thing.
And then you had lots of information for anybody who wants more information from you. There's some
Yes.
folders over there, I believe, that can give them a great way of contacting you.
Yes, so there's some general estate planning information. I have more in my bag. I think I brought 30 folders. Some general estate planning information in there, summary of the types of roles that we work through in the estate plan, and then some business cards if you wanted to call. And in my office and in most estate planners' offices, initial consults are complimentary, so.
Thank you.
Thank you.